All right, to the jury.
I'll be watching. Mr. Ragas is absolutely right. I am over there typing feverishly because at that table, we carry the responsibility and the burden of making sure that we bring you absolutely every piece of evidence to prove that this defendant is guilty beyond a reasonable doubt. And I take my responsibility serious because it's important. This matter is important. It's not a joke. It's serious because an 8-year-old little girl is dead. So I'm going to apologize in advance if I repeat myself, if I go over stuff that Mr. Abadi may have gone over, but I don't want to miss anything because I don't get a second chance to ensure that Secoriea gets justice, the justice that she deserves, the justice that her family has been waiting on for 5 long years. Now, Mr. Ragas talked about failures. I'll tell you what the failures are. The failures are over there at that table. The failure to take responsibility for what the defendant has done. He wants to put the blame on everybody else except for where it should land, and that is on his shoulders, nobody else's. He talks about the police weren't there. But what they don't want you to know, the police weren't there because the police were the ones that were in danger. They were supposed to be out there protecting the community, loving the community. But in all actuality, they were terrorizing the community. The police were their target. So the police said, you know what, let us back off. Let us give them their space to allow them to express themselves however they want to. But then it turned dangerous. And the police had no other choice but to come. So don't make them think it's the police fault that he decided to pick up an AR-15 and shoot and kill an 8-year-old little girl. It's not the police's fault. It's Julian Conley's fault. Omar rolled back through the barricades. Now, he kind of glanced over there because it would look crazy to blame a man who was driving an 8-year-old child who was bleeding to death in the backseat of a car. So he wanted to glance over that. But Omar said, I didn't know what to do. But you know what's the closest highway to get to? You got to go back through there. Otherwise, you got to go all the way around to Hank Aaron to try to get back on the highway. He was trying to get Secoriea to help as soon as he possibly could. Detective Shepard, and this is repeated, a rush to judgment, a rush to judgment. What did he tell you? I followed the evidence. I followed it, frame by frame, hour by hour, minute by minute. And you know where it led him? To Julian Conley. Now let's talk about when the defendant showed up 9 days later, because I want you to make sure that's the map. When Detective Shepard took out those warrants, that's because Julian Conley showed up and said, it's me in the red shirt, it's me in the light jeans, it's me with that AR dangling in between my legs. Because he already knew he was responsible. But did he take responsibility that day? Oh, absolutely not. So when you want to talk about 9 days and a delay and justice, it don't land with Detective Shepard. It lands with Julian Conley. Because he knew from day one. I'll give him day 2 when the news came out, because he was too busy over at Edgewood on day 1. Lies and exaggerations. There's lies and exaggerations over here, but it don't come from the state. It don't come from the witnesses that the state brought to you. It comes from the defense witnesses, and we'll talk about that. He a dumb 19-year-old, and he's in a gang. That ain't an excuse, ladies and gentlemen, to gun down a car and kill an 8-year-old girl. I have a 19-year-old son. It is unacceptable. He came from a family, law enforcement, so you know better, so you do better. He chose to do what he did. And therefore, he should hold and take responsibility for what he did. And not just try to say, oh, I'm 19.
I'm going to remind you that the state has the entire burden of proof. They've got to prove each and every element of each charge in the indictment beyond a reasonable doubt. There is no burden whatsoever on the defendant, and that burden never shifts to the defendant. Go ahead.
Being 19 is not an excuse to kill an 8-year-old girl. They talked about half-truths, lies, dangling off of Detective Shepard's tongue. Well, what they got up here and told you, Mr. Ragas, he got a difficult job. I had Mr. Ragas' job at one point. And I went to a training, and what the trainer told us in the criminal defense advocacy is, if the law is on your side, argue the law. If the facts is on your side, argue the facts. If the law and the facts are on your side, argue them both. If you don't have either, just argue. And I submit to you, ladies and gentlemen, that's what Mr. Ragas did here today. He just stood up here and argued and said anything, because that's what he got to do. But he wants to tell you there's kids doing cartwheels. I want y'all to think back and remember the context in which Ms. Broderick was showing those children. She was talking about who in the red shirt is shooting. Who in the red shirt got a gun when she pointed at those kids. That's what she was talking about. Don't let them give half-truths to make it seem like that we're glossing over that there were other kids out there. There absolutely were kids out there. Kids that were also in danger, and thank goodness they were not shot and killed too. They failed to mention that the kids had to duck down as those shots are ringing out. Because I hope y'all saw them run and scurry, running behind cars and hiding. That's what this defendant's actions caused the children out there to do. And they only showed you a portion of that video. I hope y'all remember, because we played them over and over again, zooming in, zooming out. On that other side where that Williams tent was, gunshots firing all over the place, still in the middle of the road, even after the Jeep has passed by. At no point in time has the state argued that there was only one person out there shooting. It was multiple people out there shooting. This defendant just happened to be the one who got caught. The McCoys didn't see the gun. They don't have to see the gun. When you get that indictment back there, you will read it and it will say guns being pointed in the direction of them. It doesn't say they got to see it. They even got to know about it. But we do know they know about it because we're at the barricades, and unfortunately, that video was not done right before the time that they got up to it and went inside. But you know, and we've seen that car pull up to that barricade, is down in there for about 2 minutes before they pull out and pull back into the package store. So actually, they were victims of aggravated assault twice. Inside the barricade and in front of that liquor store. Party to the prom. They just went, we gonna ignore that. We gonna act like it don't exist. We gonna fail to mention that. Because if they mention that, they gotta tell you that their defendant is guilty. Beyond a reasonable doubt. Because what did Detective Shepard tell you? He didn't have to be shooting. He says he was out there, he was at the barricade, they're all acting in concert, they're all working together. Therefore, even if he did not fire that gun once, he would still be guilty of murder, felony murder, and all the other charges that he has. But what y'all know, because y'all have common sense, which they want y'all to check at the door, but I ask you, don't check it at the door. It's the defendant, his shots, that went into that car and killed Secoriea. Now, we went back and forth, we pulled up chairs, we rolling back and forth, talking about the path and the trajectory. I ain't hear none of that today. They just failed to mention it, they just abandoned it because it don't make sense. It doesn't make sense. And camera 2, there's no zooming in of the shooter. We sat here for almost 10 minutes watching that video. At no point in time do they zoom in and say, you see where the muzzle shot's coming from? That's the man in all black, because they can't tell you that because you have common sense. You've seen this man walk around with his light jeans on and his red shirt, and you know that it's him behind that barricade, stepping out with that AR, pushed forward, pointing at that car, and he just starts to blast, like his rap songs say. And then, just no remorse. Y'all heard that before this even happened, the defendant is out in Cobb County committing acts of violence, endangering people on the highway, throwing smoke bombs in the middle of the highway where a woman is driving with 3 children in the car with her. Thank goodness that she didn't wreck and get hurt or anybody else on that highway. Then you get to July 4th, still behaving as a gang member, walking around, terrorizing the community, day in and day out. Then after that, he head over to Edgewood, still with his AR-15. And 9 days later at that press conference, want to talk about lies. Lied. Over and over again. He's 25 now. He in the jail still, wiping his nose, throwing up the gang signs with people behind him with shanks. The age is not an excuse. So let's talk about the facts. And ladies and gentlemen, I do not at all look past the fact that there were people out there for the right reason. There were people out there wanting to use their voices to combat the injustices that they believe was going on in not only in the country, but right here in our city. And they had a right to do that. Miss Salloway, by no means do I think that she is part of the gang that Mr. Conley belongs to. But see, what happens is that they were out there for good reasons, but these individuals, being Mr. Conley and his crew, came out there for the wrong reasons, and as a result of that, a child is dead. They want to blame it on the commissioners, they want to blame it on the police, they want to blame it on anybody. But the commissioner's not out there with no AR-15s. The police aren't out there with AR-15s. It's the defendant and his crew. And that gets overshadowed. Because I do think that Saturday, nobody's out there spending the night, overnight, taking showers, from going home, using the bathroom out there, dedicated to the cause and to the mission. And we are by no means saying that was anything wrong with it. What was wrong was the behavior that these defendants took, this defendant took, that does not go with this group. There are various different groups out there. You got the gangs out there, you got the protesters out there, and you just got the regular citizens that's just trying to live their life. They trying to get gas. They trying to get a couple of chips from out the store. But you got these folks not even allowing them to get to their homes. And we're going to talk about that. They want to tell you it was festive, and it may have been festive. I didn't see that videos, but I don't call it a festival when folks walking around with AR-15s and handguns and following people and making them turn around. So maybe there was some bouncy houses, I don't know, but what I did see was barricades that was blocking off the street, did not allow people to get where they needed to go. There was upliftment and love for the community. That don't look like upliftment and love for me. If you can't get where you need to go, if somebody walks to your car and you're saying, I just want to get home, and you're met with a gun to your face, telling you get back in your car and turn around. They were serving and protecting their community. They killed a member of their community. That's not serving and protecting. They were out there for healing, but it ended up in harm. And kids playing, so they want to say, ended up in a little girl, Secoriea, being killed. It was Independence Day, ladies and gentlemen. There was nothing independent about what was going on the corner of University and Pryor that day. Nothing at all. Those people were they were like, I don't know, prisoners in their own community. You can't go here, you can't come up that way, you can't go down that way. Luckily, I don't know, the bus, hey, Mr. Bus Driver, we'll let you go. But there was nothing independent, there was nothing free about those moments and those days over there. And it's not fair to the people that were out there for the right reasons. And what are they going to do? They going to tell them folks to leave? They got a whole crew out there, ganged up, ready to go, because we see them every time Mr. Conley's moving, they moving with their guns pointed and ready to shoot. But we'll talk about that. And they're exercising power and control. Now, they say Black Lives Matter. We're about police brutality. And ladies and gentlemen, the evidence is real clear. It wasn't the police that the community had to be worried about out there. It was the defendant and his gang members. And the most precious and innocent black life was lost because of them. And Mr. Obadi kind of touched on this, what was the motive? And that goes all to the gang stuff. You're going to do what I say when I say do it. I told you to turn around. I told you you can't come through here. And when you don't do what I tell you to do, then I'm going to let my gun just ring. And that's what he did. And we'll get to why I think he believed it was the McCords because of the time period. And I just told you, don't come through here. And you got the audacity and the nerve to turn around and come back through here? Oh, I'm about to show you. What did Charmaine say? She heard him say, hey, hey, like that, stop. What did Omar say? F-ins, as they're trying to just go home. Even their own witness says, she heard them as the car is pulling up. Hey, once again, trying to stop a citizen from going to and fro about their own business in a place where they have the right to do so. But until this defendant and his crew decides we're going to block it off and we're not going to let anybody do it because they were illegal barricades. They had no right, they had no authority. Anybody had the authority and the right was Omar. He should have been able to drive through that street without having to go up on the curb, not being in fear for what's going to happen to him and Charmaine and Secoriea in that car. So let's talk about the evidence that proves this defendant's guilt. You're going to get evidence, and you've got evidence through the witnesses, the physical evidence, scientific, and even the admissions and the words of the defendant himself. And we talked about Aiden Coleman, and Mr. Ragas has already said, hey, yeah, he was in a gang. He was 19, oh, just excuse it. He didn't really mean it. But he's still doing it. He's still practicing and acting up with the gang. Ms. Duffy, and we talked about that in Cobb County. Intimidating looks, his red bandana and mask. Remember she talked about the smoke bomb being pinkish or red. Loaded down with guns and ammo. What did Officer Brazanca tell you? I'm on duty and I have about 89 to 100 bullets. He walking around with over 1,000 rounds of ammunition. Because he ready. For whatever comes along, he going to take out whoever he wants to. And Mr. Ragas got up here and said, oh, Jasmine Duffy got up here and she got up and said because the state's telling these people to do this. Oh, that's him. That is not what happened. She looked at the booking photo and said, yes, that is the man who looked me in my eyes and then threw a smoke bomb under my car while I had my baby and my nieces in the car with me, putting our lives in danger on that highway. And hollow point bullets, the most lethal bullets there are. That's what he's carrying in his book bag. And the AR-15, well, that belonged to his friend. One of his crew members, one of his gang members that just took responsibility because he was already getting ready to be arrested, so we can't let them take that AR-15. I would submit you that AR-15 that they got in March is that same AR-15 that he had out there in July. Mr. Ragas wants to tell you that, oh, he's not the leader because they weren't posting. What did Ms. Salloway tell you? We didn't have to post. There were no chats going on. We knew to be out there. We showed up, and day after day, we would just come. So he ain't got to post. He ain't sending out invitations like he invited folks to a wedding. They all just showing up to run the streets. But he did post, go burn down Cobb County to get my property back. I need my guns and my ammo. He wearing his gang outfit all in through there, and we'll talk about that. He gets to decide who goes and comes in the barricades. I hope y'all, and I know y'all probably tired of looking at the video, but if y'all want to look at it, y'all get to look at it again. But there are times when you see that defendant with his red shirt on, with his white letters, moving cones, moving barricades, swinging, hey, waving people through. He is in charge, forcing people to turn around at gunpoint because he decides you can't come through here. He told them, of course, turn around. And some people, they got into the barricade. They saw what was going on. We just going to turn around. We don't even want that smoke. And just minutes before, probably not even minutes, I hope y'all saw that white car before the Jeep comes. He walks out of them shadows. You see that white lettering on his back. He goes up to that car, and that car just turns right around. Because sometimes you don't even have to point your gun. Because I'm telling you, if it's AR dangling between your legs, I'm moving. Don't worry about it. I'm going to turn around. And he's giving directions. I know it's hard to hear, but that older black man looks at him, the leader. It's good, and he said, oh yeah, he good. He can get on. He is in charge every step of the way. He gives directions to the MARTA bus driver. At the end, when they finally let him through, he walks all the way down to the end of the barricade, and he's waving. Come on, you can come through. Not no other person. Not no man dressed in all black. Not no man dressed in, not even Mr. McKinney with his white shirt and black. It is that defendant giving directions to everybody. And I hope y'all know he was standing post. Standing at post. All day long. That was his post, the barricades. Because they had certain points. If you saw, Mr. McKinney was over at the BP station, and Mr. Conley stayed at the barricades. And we know he had the barricades because he tells you in his press conference he was at the barricades. And when the Jeep pulls up, he approaching. He leading the pack because he in front. He is in front with that AR pointed, and he begins to fire, and the rest of them follow suit. Because I hope y'all know, is there a man in all black shooting? Yeah, but when does he shoot? After his leader. And not only does he step up, he follows the car all the way. And the physical evidence will show how he followed that car as it passed by, trying to get out of danger. Leading, standing post. Telling his crew where you need to go. I don't know if the McCords went where I told him to go. McKinney, go back and check. I hope y'all looked at that video and watched Mr. McKinney run back around to the other side of that package store to do what his leader has told him to do and make sure the McCords are gone. And then he comes back and goes and checks in once again with his leader. He's not just a gang member. He is the leader. And we know he had guns just all day long. And how y'all know it's him? He got on the same light jeans as he did on July 4th. Credibility. Now, the judge will instruct you that it is your responsibility to judge the credibility of witnesses, and yours alone. So you get to decide who came in here and who told the truth. I submit to you that the state did not put up anybody that told you anything but the truth. Now, they want to call Detective Shepard a liar, and he's not a liar. They just mad that the evidence that he got led to their client. What did Samantha and Christopher McCord tell you? They pulled up to the barricades. Mr. McCord describes a light-skinned male with a long gun. Now, I mean, it was a long gun. That gun looked really long to me. He didn't have to say it's a rifle or not, it's a long gun. He forces them to turn around, and then he gives them instructions. And then Mr. McCord, after seeing this defendant admit that he was down there, he says, that's the dude that met me when I was inside the barricades and told me to turn around. And how we know it's him that met him at the barricades? Because he follows him after he turns around. There's no doubt who that is. And I know y'all was probably tired of hearing about States 112, light jeans, red shirt, but we got to prove it. I have a responsibility and a duty to prove to you beyond a reasonable doubt that it is that defendant that committed each of these acts. And so if I got to tell it to you over and over again, I will do it over and over again because this is my one shot. Aggravated assault, like I told you, twice. Now, Mr. Ragas talked about somebody squatting down ready to shoot. It was his client. Ready to shoot. Now, Charmaine Turner, she told Detective Shepard everything she could. Now, one time did she lie to Detective Shepard Were there men out there with black shirts on, dressed all in black, dressed like the police, dressed like the militia? Yes, they were. Were they all armed? Yes, they were. Were there men in all black shooting guns? Yes, they were. He says we didn't ask her the question about whether or not it was the defendant that shot Secoriea. We didn't ask her because she said, I don't know who shot my child. I just know my child was shot as I passed through a barricade with armed men. And who would expect her to know anything else? Because he started with the mother. The mother in the back of that car. First of all, she said, I'm on my phone. Secorea's back there on her phone. Next thing I know, guns or fire is coming into the car. I reach back to get my child, and the last words I hear my child say is, Mom! Crying out in agony and pain. So he wants her to be able to tell you about a red shirt. The only thing red that she was concentrating on was the blood that was pouring from her baby body as she tried to press on that wound to keep her baby alive. I'm a mother, and I know what that feeling feels like, to hold your child the first time they take their first breath, as their heart beat for the first time. I can't imagine the anguish it feels to hold your child as they take their last breath.
Objection, Your Honor. May we approach?
She's focused on her baby that is dying in her arms. So it is not fair for him to say, because she cannot point out this defendant, because we ain't got to worry about her pointing out. The video's pointed out. And didn't I tell y'all two things to be true at the same time? Could there be men in all black shooting and this defendant shooting? Absolutely, and you know it because it's on video. Omar, it's men in all black. They bounty hunters. He gave a picture to Detective Shepard. Yes, he did, because Omar is like, y'all, that man is driving that car. He made the decision to drive through that barricade. The responsibility on him weighs heavy. Y'all can see it on his face. So he is doing whatever he can, giving Detective Shepard whatever information he receives about who could have been the people out there that were shooting into that vehicle. He never said definitively that man didn't shoot. He never said that. What he said was it was men out there dressed in all black that were shooting. And is that true? Yes. Was the defendant out there shooting? Yes. So two things can be true at the same time. Don't try to put the onus on the man behind the wheel. The man behind the wheel was trying to make a decision in the most traumatic event he has probably ever experienced in his life. What do I do? Where do I go? Because when you pull up to that barricade and you see them people, you got to make a decision. And we came Monday night quarterback, I guess it's Tuesday night quarterback now since it come on Monday, to decide if you pull up to a barricade and you're trying to drive through, it's armed men in front of you. You don't know what they may do if you just turn around. So I'm just going to push through. And there's nothing wrong with that. He was trying to be a protector. How can I get them to safety as quickly as possible? We can't blame him. The blame lies on the person that pointed that AR-15 at that car and let off 8 rounds into it. We lucky it wasn't Charmaine, Omar, and Secoriea. And what did Omar tell you? I wish it was me. That's who's taking responsibility. And he said, I'm going to get an attorney. There's nothing wrong with that. He's like, I'm driving the car. I want to make sure that nobody thinks that I did this. I'm responsible for it. Because I don't know if you heard the little tricklings of, oh, the person in the car was shooting too. So he's trying to make sure I'm protected. But what he does say is black men and all black were out there shooting, and we know that to be true. And we also know it to be true that the defendant was out there shooting. Now, the defense witness, Ms. Salloway, like I said, I think she came with good intention, or at least she was out there for good intentions. And she was trying to do what she could to help. But the things that she told us was real important, and it was consistent with Omar and what Charmaine told you. As the Jeep pulled up, I heard somebody yell out, "A." The Jeep went up on the curb and shots rang out. And she told you, as the Jeep passed by, I saw shots in the back area behind the Jeep, and the windows of the Jeep were rolled up. Now, when she get a little fuzzy on her credibility is that the man at the back barricade was shooting. Well, ladies and gentlemen, y'all get to view the videos. Y'all get to decide. There doesn't appear to be muzzle flashes. She said she didn't see muzzle flashes, but she thought the man was shooting, but she really couldn't tell us where she was standing in the Wendy's parking lot. And then at some point she started saying, well, I heard what happened. So I don't know if she heard it that night, heard it since this trial's been going on, and feels like that's what I saw. But to me, that's just a little red herring. But what she does tell you is the shot, as the Jeep returned, she heard some more shots. She don't know where they came from. They don't know who they came from. And I think she said, Mr. Ragas wants to tell you that the man was not ducking for cover. That's what his witness said. He ducking down. He moved all the way to the other side of the barricade to avoid the shots that this defendant is firing out in his directions by the barricade. She tells you men in black are shooting. Absolutely, they are. But what she didn't tell you, she never said, that defendant didn't shoot. And what, in fact, she told you he did, but we'll talk about that. And now it's Detective Shepard's fault. Detective Shepard told you I was working 12, 14-hour days to figure out what happened to this baby. I'm canvassing the area. I'm trying to get people to talk to me. I'm not getting any cooperation. The people that are talking to me, it's exaggerated for what they're telling me, because when I look at the video footage, it's not corroborated by what they're telling me. I'm getting information from social media. He never denied that there were men out there shooting in black. In fact, what did he tell you? If I could have identified them, I would have put a bolo out for them. But I didn't have any identifying photographs where I could see their pictures, their faces clearly, to put out on a bolo. He never got a positive identification for them. The only two people he was able to get a positive identification for was the defendant and Mr. McKinney. And when he got those, he put it in a bolo, put it out there, and he got those individuals to then come in and say, yes, that is me that you see. And we know that he's not in a rush to judgment. Because what did he tell you? I didn't charge McKinney. Because as I'm looking at those videos, McKinney is not at the barricades. So I'm not just out there trying to charge anybody that I see with this homicide. I want to make sure that I charge the right person, because I have all the evidence to show me that it is that person. So it's not a rush, ladies and gentlemen. He's following his evidence. And thank goodness for Mr. Camber, because we were able to get that video from Martin Lutz. We were able to get those clear images. And if you recall, there are other images as that bus is turned around on the side where there are other men out there with guns, and they got them posted, they got them pointed up, but you can't see their faces. So you can't put out a bolo for somebody whose face you can't see. And he told you those are muzzle flashes. At least two we see as that Jeep passes by. And what did he tell you? I didn't know. I did not know who my suspect number one was. I knew what he looked like. I knew how he walked. I knew what he was wearing. I just didn't know his name. I didn't know his name until he showed up with his attorney and said, that's me at the barricades. And then Mr. McCord then calls and says, hey, yes, I recognize that man as being the person that pointed a gun at me. And lo and behold, what do we have? Video footage of that defendant pointing a weapon at Mr. McCord and his wife as they drove away. So it ain't just believe Detective Shepard. Everything he says is corroborated by evidence. And Ms. Cassandra Salloway, what did she tell you? She identified that muzzle flash as that defendant is standing in the middle of that street, firing off. And what did she tell you? The jeans are so light, they blend into the street. Who is the only person out there with light jeans on? Because everybody else is smart enough to wear all black, except for the defendant. So even their witness has identified the defendant as being the shooter out there. Black do-rag, his twist, his light skin, his red t-shirt, his light jeans that we know belong to him because he had them on in another picture with another gun, his black bag, his black shoes, and his gait. What did Detective Shepard tell you? The way he was walking, and y'all saw he's kind of walking kind of funny because of that gun. It's messing up the way that he walks. So that's how he's able to follow him. from the BP, from the package store to behind the barricades. Every step he's making is distinctive. He decided he wanted to be seen. Because I'm going to rep my gang. I'm going to put on my gang t-shirt, Pyro, Elm Street, Pyro, whoop on the back. I want to be seen. And he was seen by each and every one of those cameras out there. And he was seen shooting at that car and killing that baby. Don't leave your common sense, ladies, at the door. You've watched the videos over and over again. Believe what your own eyes tell you. Miss Young, you talking this. Trust the videos. You've seen them enough. If you want to see them again, you can. I think Mr. Bobby said it now. We didn't even coordinate on this. Context clues. Those are important. I have a son, and he was real younger. And I said a word, and I said, how do you, and he said, oh, that means such and such. And I'm like, how do you know that? He said context clues. Ladies and gentlemen, use your context clues when you get back there. Red shirt, white lettering, light jeans, black satchel, AR-15, funky little walk because of your AR-15, your light skins, your twists, and who you come up with. At 9:45:21, this defendant is standing at his post. Light jeans, red shirt, black shoes, black satchel, light jeans, red shirt. You can kind of see that AR hanging down right here. Black shoes. At 9:45:21. At 9:46:02, less than a minute, that Jeep is pulling through. He has not moved. You saw the videos. At no point does he leave from those barricades. The only time he leaves from those barricades is when he steps to that Jeep as it pulls through. And here he is again. AR extended. How do you know it's him? Them light jeans, that dark shoes. You can kind of see it here in red, but it's dark because if you all know when you take pictures, if the lighting is behind you, it's going to be dark. That's why kids always tell me, get the light, you got to get the light so you can make sure your colors pop. But it's enough for us to see it ain't. If it ain't in black, ain't the man in black, ain't the man. Right here, light jeans, dark shirt, AR. And what did Samantha McCord tell you? If you point a gun, you ready to shoot a gun. Not less than 5 minutes later. I hope when we don't go through the timeline, this is what he's doing. Pointing his gun. And when that car comes through, 2 to 3 minutes later, he is ready to shoot. And that's exactly what he does. And I know it's blurry, ladies and gentlemen, but I hope you can see it enough. This him. Lord God. Now where are these other men? They're back here. Where's the Jeep? Tracking his every step. That's him, ladies and gentlemen. Now, when Mr. Ragas got up here and showed you this video, he didn't want to zoom in this close. Because if you zoom in this close, you get to see his client committing this murder. Physical evidence in this case, ladies and gentlemen. Because we're not just going to bring you the witnesses. We're not just bringing you the video. Does the physical evidence show that this defendant is guilty. And we talked about these videotapes from every angle. Not just one angle, not just a half an angle, every angle. Tracking him so you don't have to wonder, is it him? Did he go somewhere else? There is no doubt it is him each and every time. Nine 12:45. Nine 13. Nine 13, 50 seconds. Nine 15. Directing the marker, telling him where he can go. Nine 38. Back at his post. Moving the cones. Moving in on the McCords because they have challenged his authority. Nine 40. Every minute, every second. The defendant is present and making decisions as he's terrorizing and victimizing people in the community. y'all see Mr. King go that way? And he goes. 9:40. (9:45), 24 seconds. Just seconds before that Jeep comes through. You can't miss him, the white lettering. One shot, two shots. And we show y'all, it's another man in all black shooting. We're not trying to hide from it. Because it doesn't matter. Everybody at that barricade is responsible for Secoria's death as a party to the crime. What's the physical evidence? Defendant there before, during, and after the shooting. What's the path of those bullets in that car? All on the driver's side. Now, Mr. Ragas started to talk about path and trajectory and when they have to come from the right. None of it makes sense because all of the defects are on the right side of that car. The muzzle flashes that you see coming from that defendant's gun, when the police get out there and they find shell casings right there in the area where he was standing, where he was firing his shots. 6 shell casings, 7 of them. How many defects in that car? 8. And we saw the pickup man coming by picking them up. So maybe he was lucky enough to get one of those shell casings that came from the defendant's gun. Driver door, back driver passenger side door, bottom of that passenger door, the side panel. So we know that the shots came into that car from the left. That's what the physical evidence tells you. And then those last two, and I will submit to you, ladies and gentlemen, that last fatal shot came through marker number 8. This is the passenger side, and you'll have the pictures back there that you can look at. They try to say, oh, well, isn't that maybe some bullet holes? It's dirt, ladies and gentlemen. Through that back trunk, through the back panel of that seat, through the seat, into Secoria's back.
Objection, Your Honor. May we approach?
Yes. Okay. We've just stopped because part of the video creation was starting to show. There was an immediate objection. Objection is, go ahead.
Ron, that's evidence that is not been found. That's a demonstrative that we have never seen before. We have never vetted. Perhaps we should have kept our expert. We've not had our expert look at it to gauge whether it's representative of anything. It's just something that, again, that we have never seen this demonstrative, and we've had no opportunity to vet it, to check for any scientific accuracy, or to see if it's even representative of anything, to determine whether the jury should see that. So as it is right now, the jury is seeing a piece of evidence, because that's what it is, evidence that has never been shown to us before. We move for a mistrial, Your Honor. We can't undo it. The jury saw it. The jury saw the representation, the 3D animation. It's improper.
Okay, let's see. First of all, can we look at what it was? And I'll say that we saw just the very, very initial beginning of this, so.
We didn't see the very beginning of it. The jury saw the whole thing move. Like, while we were talking.
While we were talking it.
While we were walking up there, it was still moving.
Okay. Okay, so to narrate that video, we saw what I guess is your theory of how this happened?
Absolutely, it's just a reenactment. There's no less than bringing a car and putting a car right there and having it on wheels and being able to move and walk alongside of it and maybe with a paint gun shoot at it to hit the doors and the areas in the trunk and the area that the state's evidence indicates where those bullets went into the car. There's no measurements on there, there's no trajectory information, it is just a reenactment of the video that you see as the defendant walks up to the car and it's moved, the car is moving because Mr. Ragas, in his demonstrations that he did during the trial, wanted to make it appear that the car just was staying stationary, it wasn't moving, and therefore his client could be at the back of the car. This is the state's theory how his client ended up at the back of the car and those shots ended up in the back of that trunk and then into that baby.
New evidence. I'm sorry. It's new evidence. We've not had an opportunity to view it, to object to it, to question the creator of it, to do anything that we would need to do. And you got a case. I don't have a case yet.
Yes, Your Honor. The case of Rickman v. State, that's 304 Georgia 61, a 2018. I'm sorry. 304 Georgia 61, a June 18, 2018 case.
What's the name of it again?
Rickman, R-I-C-K-M-A-N v. State. Demonstrative evidence, which includes reenactments and pictures used to aid the trier of fact in understanding the issues of fact at trial, is irrelevant and inadmissible unless accompanied by a witness testimony that shows the demonstrative evidence is substantially similar to the actual conditions or events at issue.
It's not an evidence, Sean, it's part of my closing argument.
You can't even use the closing arguments if you haven't to put it as in as evidence. The point is, there's a process to how to use demonstrative evidence. If the state literally jumped over and skipped the process, and now they're throwing it in front of a jury to say, this is what happened. These are the facts based off of our testimony. That is not how demonstrative evidence is supposed to work.
It is not demonstrative evidence.
Okay, do you, okay, hang on for a second, stop fighting. I'm going to read the case. Do you think that if before closing arguments she had shown it to you and given you a chance to object, that might have been used? Or is your position it had to be evidence in the trial?
It should have been evidence in the trial, but at a minimum, it should have been shown to us before closing to give us an opportunity to object to it being placed before that jury. And we haven't had that opportunity. And we would have objected, but we just haven't had that opportunity to do that now because they sprung it on the jury without ever giving us any opportunity for a meaningful examination of it.
Okay, let me read the case.
And Ron, can you make certain you read the coordinates?
Yes. Yeah, if anybody needs to take a break, that's fine.
Which point are you looking at? They're like 6 bullets.
2, probably. Looks like what he's talking about.
Actually, yes, if you hit 2 and go down to the middle of the cases, that's what the language is.
Is it 306 Georgia 61?
304 Georgia 61, 2018 case, Richmond State. Inside right, 464.
Okay, I'm going to step off the bench for just a second because I'm only getting part of the case.
What's that?
You hadn't contested yet?
Yeah, you noticed.
I thought that.
I think the TV's going bad. I think the TV's going bad.
You did the deal, laptop charge. That's what I have no problem. I have no problem. Did y'all need to borrow a power cable or something?
If you need to borrow, yeah, if you got to borrow,
Oh, wait a minute, no. So, so you just, so this is just power that y'all just trying to get these young guys.
it has power, but it's all plug-ins in the back.
Well, this wouldn't cause this.
That's what I'm saying.
I kind of.
We've been doing it. We've been doing it all week. And now
It might
stuff
be,
work.
yeah, video cable or.
The IT person. Oh, you are the IT. I know that, but I was just joking with you. You got a job.
me do the math. What time did you say? Oh, it was, yeah. 1:15. It was definitely 1:15. Okay, and then 2:08 is when we started. So let's say 3 minutes each. That would leave. More than that, I think she's okay. Okay, first things first, I want to make sure that we don't steal time from your closing because we stopped repeatedly. It looks to the court like you have about 11 minutes left. Anybody disagree with that? Looks to me like she's got about 11 minutes left. From when we cut off before the, okay. Around 11 minutes too, okay. So that case was close but not quite, and I'm glad you brought it to the court's attention. It's good information. I think under different circumstances in this situation, if the rendering had just been showed to the defense, the court may have admitted it over the defense's objection with proper instruction to the jury. But because it was not offered prior and we didn't have that discussion, I think out of an abundance of caution, we're not going to play it for the jury. I'm going to just give this instruction and you'll be allowed to just continue your argument. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago. This was not evidence in this case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering as evidence in this case. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Anything else that you would like me to say?
I think it is, with all due respect, I'm sorry, I think it was way too generous to the state.
I believe it's improper.
Earlier,
When Detective Shepard says some things that were improper, the court inserted the word improper into its instruction to the jury. I think the jury should be told that that was improper. And secondly, what I will characterize as what lawyers say is not evidence. I'm lumped into that bag with them. They did something that was improper, and I don't know that we need to do a both sides thing in terms of what lawyers say, in terms of what all of us say is not evidence. That is factual, but the situation that compels this instruction is something the state did, and I think the jury should be told what the state did, again, was improper, and disregard that and place no weight on it.
And, Your Honor, I don't believe it's improper for the state to be able to argue our theory of the case and what occurred out of it. So calling it improper, I don't think is a fair statement of what the state has done. We are allowed to illustrate what we believe. It's argument, and they can decide. I don't believe that's how them shots got into the car, or I do believe it. It's up for them to do that. For me, illustrating it is no less than, like I said, me wheeling a car. I'm sorry.
You're okay.
And pointing at it right here in open court. That's nothing that I would be able to put before Mr. Ragas and Mr. Weaver prior to it starting. And there's nothing that prevents us from doing it because it does not have to be entered into evidence because it is not evidence. It is the state's argument. It is the state's theory of the case.
And if I recall, I saw the word evidence at some point under the, I don't know if it was under the heading of physical evidence, but it was under the state's own heading of this is evidence.
There was no heading on that slide, Your Honor.
Perhaps not that slide, but it was billed as whatever the case may be.
Well, they can have a heading on a slide that lists the evidence that says evidence.
But that should not have been listed as evidence at the point I'm making, Your Honor.
And it was not, Your Honor. The slide had no heading at all.
Okay.
And it's not even illustrative of the state's theory. Detective Shepard said the shooter was stationary. That was a graphic showing a moving shooter. So it wasn't shown to us, and it's inconsistent with their star witnesses' testimony as to what occurred.
Okay.
It's wrong on a lot of levels.
Well, it's not wrong on the video because he's shown moving on the video.
Okay, I understand everyone's frustration. This is a situation that could have been handled prior to closing arguments. So, so I'm going to go ahead and give an instruction on this, and motion for mistrial was denied. Anything else that you want to put on the record?
No, Your Honor.
Okay.
I would actually like the instruction read once the jury comes back in with any dangerous charges as well. I think because of how inflammatory what the state just did is, I think they need to hear it more than one time, Your Honor.
Okay.
Isn't part of the pattern charge that nothing?
Part of the pattern charge, there's extensive information about in the pattern charge about attorneys' comments not being evidence. Okay, we can take that up after we finish closing. We're ready.
Are you going to read within, is that the instruction, or have you changed it, have you modified it? I'd like to hear the instruction before this one, if I may, Your Honor.
That's fine. Yeah, I think I've said you are not to consider this computer rendering as evidence in the case. I am happy to make it you are not to consider this computer rendering, if that is closer to what you were hoping I would say. I'm not going to say that it was improper. I think under other circumstances that video could have come in.
Under the right process.
Under the right process.
That's the issue.
Well, and yeah, it's hard. There's not rules of evidence about how to do that. Okay. We're ready for him. Okay, remember you got 11 minutes left. You had 14? Sorry. Let's see, what does Madam Court Reporter have?
He waiting back, Your Honor.
You guys are really bad.
She started off with an hour and 6 minutes. She started off with an hour and 6 minutes left.
All right, the jury. Judge, that kind of court.
Okay, members of the jury, we're about to resume closing arguments. I need to give you this quick instruction. I'm sorry, I'm not looking at you. I need to speak into the microphone for you. A computer rendering of the state's theory of how events in this case might have occurred was played several minutes ago before the break. This was not evidence in the case and was merely an illustration of the state's theory of the case. You are not to consider this computer rendering. The arguments of the attorneys are not evidence. You are to base your deliberations and decision in this case on the evidence that was admitted in trial only. Okay, you can resume your argument.
Thank you, Your Honor. Ladies and gentlemen, I hope you remember in the video where you can see the defendant step up and move along the left side of that car, firing shots into it, and then the evidence indicates there are 8 shots in it, following that pattern that the defendant took as that truck passed by. Then you have the shell casings that you saw from the crime scene tech. Each and every one of them that landed there, that's on that side where that Jeep passed by, 556, 556, and what did Ms. Van Home tell you? That's consistent with being fired from an AR-15. 8 shots, 7 shell casings, 7 of them are 556, all shot from the same weapon, right in the area where this incident occurred. And there was some rumbling about shooting from the car, but there's no evidence. Mr. Ragas talked about humidity and all of that stuff, but there's no evidence of that. The only evidence is that this defendant walked up to that car and fired off 8 rounds into that car and then caused the death of Secoriea Turner. And we talked about the man in the black walking down the yellow, well, all the way to the barricade. He's furthest away. So we know, that's the safe theory, that that is not the bullet that went into the back of the car and killed Secoriea. The next guy that's in all black, he's walking along the yellow line, and what's found where he is, a .38 projectile. And then there's none at that back barricade, so we know nobody back there was shooting. We know the only person that was shooting, where these muzzle shots are coming out, is the defendant with his light pants on and his dark shirt and that muzzle flash coming out of his gun while these three people stand back here doing nothing. The scientific evidence, the way that it goes through the back trunk, through the back of the seat, through the outside of the seat, into Secoriea. And like I said, they failed to mention that, so I'm not going to waste my time on it because they know it was foolish too. 5.56 shell casings, 5.56 projectile, type of weapon that can fire, 5.56 AR-15. The only thing we ain't got to give you is the AR-15, because what did Ms. Van Horn tell you? I can look at it, and I can test against the weapon, and I can determine that whether or not it is a metal weapon or I can eliminate it. If I had it for you, I would give it to you, but I don't. The medical examiner. And I know it was hard looking at these pictures, ladies and gentlemen. I've been doing this a long time, and it's difficult each and every time, because nobody should have to look at a baby laid out on the table with a gaping bullet wound in the back of her. But the only person that is responsible for causing that wound back there sits right there. That's on him. Went through her body with so much pressure and so much force, it starts to break apart. We have everything but that gun to be able to tell you this is exactly the gun that did it, because we know all of those 5.56 shell casings came from the exact same weapon. Don't believe me, don't believe the videos, don't believe the physical evidence, don't believe the science if you don't want to, ladies. Just believe him. My grandmother always told me, when somebody tell you who they are, believe them. When they show you who they are, believe them. And this defendant has shown us who he is and what he is capable of over and over again. Cobb County with his red bandana, his gang tattoos, his gang language, burn it down. ARs everywhere, every photograph you got with his AR. Pointing it at people, terrorizing people, allowing a community to be locked down because he decided, I'm claiming this as my gang territory. And when he shoots that baby, where he go? Over on edge with his AR-15, still dangling between his legs. But when he shows up to say, oh, that's me, what's conveniently gone? One of those distinctive markers, those twists. He's trying to change, he's trying to hide. But ladies and gentlemen, y'all tell him he cannot hide. He is no longer in the shadows. You see him clearly as who he is. He may sit over there with a suit on, with his hair cut, looking nice, but that's not who he is. He is a killer. We saw that in his video at the jail. August 5th, 2025. Just days before this started. This is what he's doing. What is his words? I empower.
Don't play with him. Yeah.
If I tell you, if I show you, believe it. This is who I am. What he got on him? His gun. Because where he don't go, we don't link up without our sticks. He tells you I had an AR-15. He tells you I was at the barricade. If he don't, even though he don't tell you he shoot, I told you, party of a crime, he is just as guilty. But we know that that is a lie. He shot 8 times into that vehicle. But see, he didn't know the story. He didn't know that Detective Shepard had those videos. He thought I could step out and say, oh, it was me. He didn't realize it. So what did he do? He lied. Mr. Ragas want to talk about lies? That's what that defendant has done. He lied. He got up there. Somebody was hit. Y'all seen that video. Not one person was hit. Not one person hit the ground and jumped up and started shooting. A lie. He said he wasn't shooting. Muzzle shot after muzzle shot. He lied to his attorney because Jackie Patterson only repeated what the defendant told him because he wasn't out there. He hadn't seen no videos. He's a liar and a killer. That's what his autobiography tells you. And what does he say? After he sees this, I'm going down the road, I ain't shooting. I ain't even have a gun. Lies. What did he say when they posted the bolo on McKinney? I was out there, bro. Bro ain't even shooting. He's talking about McKinney. Every man out there was shooting at the car. He the only end that walked to the store. It happened at the burnt down Wendy's. Everybody was shooting but McKinney. That included him. He told y'all he was shooting because everybody out there was shooting. But he's the one that shot and killed Secoriea Turner. Every piece of evidence the state has brought points to this defendant's guilt. The law, the eyewitnesses, the physical evidence, the scientific evidence, the defendant's own actions. And ladies and gentlemen, I implore you to use your common sense. And when you use your common sense, it leads to no other road than the defendant's guilt. Now, we've talked about him for days now. This case is about Secoriea Turner, 8 years old, just riding in the backseat of the car with her mom, coming from celebrating the 4th of July, having fun with her family, her friends, playing with her cousins, watching fireworks for the night. She was having so much fun. What did her mom tell you? She didn't want it to end. I want to go hang out with my cousins. And her mom was trying to make that happen as they headed down University. Nobody knew that day that that was going to be the last time that Charmaine got to go to the nail shop with her baby. That was going to be the last time that Secoriea got to go to a barbecue and a cookout with her grandmother and her cousins. That was going to be the last time that she got to play with fireworks. That was going to be the last time she got to call to play with TikTok, because we know that's what she liked to do, make her TikTok videos. And that's what she was doing back then. And nobody knew it was going to be the last time that she got to call out her mother's name. "8 years old. It is not fair. It is senseless, and it was unnecessary." But the defendant wanted to stake his claim. 4th of July is supposed to be about celebrating with your family. For Secoriea Turner's family, forever now. 4th of July is not about celebrating. It's about grief, and it's about mourning. This coming November, Secoriea would have turned 13 years old. A milestone for young kids, especially little girls. She will never get to reach that milestone. Mr. Ragas told you that the defendant was making dumb decisions because he was 19. Secoriea will never have an opportunity to make dumb decisions as teenagers do. Her mom told you how she wanted to go to Spelman, and Mr. Ragas told you how his girls got to go to their HBCU. Secoriea will never get to go to Spelman because of this defendant. Hopefully one young girl will get to go because they have a scholarship in her name. Now, Mr. Ragas talked about Ahmaud Arbery. I am from Brunswick, Georgia. I live one neighborhood over from the neighborhood where Ahmaud was killed. I went to church with his aunts. So I know what it feels like to have someone in your community taken because of senseless violence. In his honor, they do a 2.23-mile run because those are the last miles that he got to run that day. For George Floyd, they have a moment of silence for him. 8 minutes and 46 seconds, because those were the last minutes of his life. At some point, hopefully, not just a scholarship, but maybe 8 minutes of silence for Secoriea for the 8 years of her life, or the 8 bullets that flew into that car and took her life. That's what we can do for her in the future. But today is a day that you can give this family the justice that they finally deserve. Mr. Ragas talks about 9 days of rush to judgment and rush to judgment. I tell you, ladies and gentlemen, it has been a slow crawl to justice for Secoriea and her family. They have waited 5 long years, 1 month and 22 days. I ask that you don't make them wait 1 more day, 1 more hour, 1 more minute. Tell this defendant what he already knew when he stood up at that press conference. He is guilty, guilty, guilty of each and every charge on that indictment. Thank you.
Okay, members of the jury. My instruction to you is going to take about 45 minutes. Would you like to eat before you give the instructions? Okay, we ordered food for you, so you can just go back and have that. Just make sure that you don't discuss the case amongst yourselves. Don't do any research. Don't look at your phones. Don't talk about the closing arguments. Just eat lunch, and then we'll come back and have the judge.
All right, so jury.
You can eat quick? Okay, that's fine. You let us know. We're at your beck and call. You think about 15 minutes?